Arkin. So today we'll be considering Part 55 CPR possession claims. If you do have any questions, feel free to drop me those questions at the Q&A at the bottom of the screen. And my email address will also be provided at the end of the webinar, so feel free to drop me an email as well. What I'll intend to do is select the most popular questions and get back to you on them, or post them along with the webinar on Chamber's YouTube channel or on LinkedIn in due course. So the purpose of this webinar is essentially to examine the current state of play in the field of claims for possession and enforcement of possession orders pursuant to Part 55 of the CPR. You may be aware of the applicability of the current stay provisions that are in force as a result of Practice Direction 51Z and the latest extension of the same up to 23rd of August of this year. With that in mind, what we'll be considering is as set out on screen. So PD51Z itself, which I've conveniently labeled the blanket stay provision for the reasons which I'll come on to. A recent case law, including the seminal decision in this field of Arkin and Marshall. The three key exceptions to the blanket stay provision. The suggestion that actually injunctive relief may be a favorable alternative whilst the stay is in force. And what the practitioner could do right now in light of the stay. So in light of the COVID pandemic, you may be aware that PD51Z was introduced. Essentially, as set out on screen, the general rule is that all proceedings for possession brought under Part 55 and all proceedings seeking to enforce an order for possession by a warrant or writ of possession are stayed for a period of 90 days from the date this direction comes into force. This direction came into force on the 27th of March of this year, and it is an automatic stay. Part 55 possession claims are defined at Rule 55.1a of the CPR as a claim for the recovery of possession of land, including buildings or parts of buildings. And what this covers is essentially tenancies and licenses that benefit from protection from eviction under the Protection from Eviction Act 1977. That includes tenants in social housing, the private rented sector and some licensees, mortgage repossession claims, possession claims by landlords against leaseholders on the basis of forfeiture, and residential occupiers who have become trespassers as a result of a notice to quit. That is why I've labeled the stay provision as a blanket stay provision, because it essentially covers Part 55 on the whole, aside from the stated exceptions, which I'll come on to. One thing to bear in mind, however, is that the government guidance was introduced when we entered lockdown by the Ministry of Housing, Communities and Local Government, which then they essentially suggested that the stay provision does not apply to lodgings, holiday lets, hostel accommodation, and accommodation for asylum seekers, because they are essentially excluded from the protection under the Protection from Eviction Act. That is not something that is made clear on the face of PD51Z. Now, the policy reason behind the general rule is essentially to ensure that the administration of justice, including the enforcement of orders, is carried out so as not to endanger public health. That's set out at the start of PD51Z. And what is important is on the 18th of April of this year, the blanket stay provision was amended to include the stated exceptions as set out on screen. So the stay doesn't apply to the issuing of Part 55 possession claims, trespasser possession claims under Rule 55.6, i.e. applicable to persons unknown, interim possession orders, and applications for case management directions which are agreed by all the parties. As I set out earlier, injunctive relief is an exception which was in place when the original provision was introduced. And on the 5th of June, the blanket stay provision was extended to the 23rd of August of this year, and the provision itself ceases to have effect, at this stage at least, on the 30th of October. The seminal Court of Appeal authority in this field is the case of Arkin and Marshall. And the critical question answered by the Court of Appeal, and one which practitioners will be thinking about the most, is whether the court has jurisdiction to lift the blanket stay. The simple answer is yes, but the threshold to reach is a very high one if an application is to be made. Now, the court acknowledged in this case The general discretion available to impose and lift stays is one that is available in light of the court's case management powers at Rule 3.1 and Rule 3.12F of the CPR, along with Section 49.3 of the Senior Courts Act 1981. What the court stated was that the power to impose a stay included a power to lift it. And therefore, the blanket stay provision could not be read as formally excluding the operation of the court's case management powers to lift the stay. So the judge retained, theoretically at least, a power to lift that stay. However, the court stated that the proper exercise of that power was informed by the nature of the stay itself and the purposes for which it was introduced. In that respect, I'll just pull out a couple of key points from the judgment itself. Now, the court stated that Practice Direction 51Z imposes a general stay on proceedings of the kind to which it applies, initially subject to no qualification at all. The purpose was that during the 90-day period, the burden on judges and staff in the county court of having to deal with possession proceedings, which are an immense part of its workload, would be lifted. That purpose is of its nature a blanket in character and does not allow for distinctions between cases where the stay may operate more or less harshly on typically the claimant, and that it would be fundamentally, fatally undermined if parties affected by the stay were entitled to rely on their particular circumstances, however special they might be said to be, as the basis on which the stay should be lifted in their particular case. The court stated that whilst they wouldn't go so far as to say that there will be no circumstances in which it would be proper to lift that stay, they found it very difficult to envisage such a circumstance. The only one that they could think of was where the purpose of PD51Z would be defeated, and there'll be an endangering of public health. The court also said that the stay is unconditional and that normal case management reasons would not be good enough to justify lifting that stay, and that they would strongly deprecate parties troubling the court with applications that are based only on such reasons and which in truth are bound to fail. So what the court said was that the power to lift the stay is really theoretical and it would be wrong in principle to use it. But they kept it open and said that in some circumstances or exceptional circumstances, it may be appropriate to lift that stay. They didn't really give any examples. Now, I was asked to provide some thoughts on potential applications prior to this webinar to disapply the moratorium in serious ASB cases, and how bad it would need to be for the court to entertain such an application and the correct forum for such an application. Now, from the reading of the judgment, it is very clear that the starting point militates against lifting that stay. So any antisocial behavior would have to meet that high threshold, would have to be the most of extreme circumstances. Indeed, it would most likely have to be something which endangers public health. The court made it very clear that however special the circumstances of a particular case may be, an application is unlikely to succeed. So it's my view, at this stage at least, that without clear set examples and the court's very much reluctance to suggest that the stay should be lifted in most situations, that an application to lift the stay, even if it is in relation to antisocial behavior cases, is one to stray away from. It may be appropriate in those types of cases, in which I'll come on to a little later, is to make an application for an interim injunction. In terms of the appropriate forum to make such an application, this is not something which the judgment really touches upon, but in light of the requirements of PD55 and Part 55, it would be said that the appropriate court to make such an application would be the issuing court or the court serving the address of the land or the property in question. Now, two other key important or key authorities in this area is the case of Okoro and Copeland. Dealing with Okoro first, this followed on from Arkin and Marshall and dealt with the question as set out on screen, whether the blanket stay provision applies to appeals from possession orders that were extant when the stay began. The answer to that was yes, the stay provision did apply to appeals. Now, again, I'll go to the judgment itself, provide the key sections. The court stated that the wording of paragraph 2 was broad and that they stay all proceedings for possession brought under Part 55. Now, I've made that clear in bold on the screen. The key word there is brought, and that as a matter of ordinary language, proceedings brought under Part 55 are brought under Part 55 even when they are under appeal. And that when looking at the proper construction of paragraph 2 of PD51Z, it was there to protect and manage court capacity and to ensure the effective administration of justice and the endangering of public health. Again, looking back to the policy reason for PD51Z itself. And that it was much applicable to staying appeals as by staying first instance proceedings for possession, and that therefore it applied to all proceedings for possession brought under Part 55, including enforcement proceedings in relation to rules that fall outside of Part 55. So that could include, for example, enforcing an order of sale under CPR 73.10, for example. And what's important is the court stated that PD51Z was to include every stage of Part 55 proceedings, including first or second appeals up to a final judgment in the Court of Appeal, but would not include appeals to the Supreme Court, only for the reason that that fell outside the jurisdiction of the Master of the Rolls in making practice directions under Rule 51.2. So therefore, the stay is truly a blanket stay. It applies across the board for Part 55. And when we talk about enforcement of possession orders, actually it goes beyond Part 55 proceedings as well. As set out on screen, the court also touched upon and suggested that the stay provisions also apply to applications made by defendants under by analogy, Rule 39.35, to set aside possession orders for the defendant's non-attendance. Another authority to look into is Copeland and Bank of Scotland. And as set out on screen, essentially what the court said here was that the stay could be lifted in the very specific scenario where a reserved judgment was to be issued and to make consequential orders on an appeal that had been heard before the blanket stay provision came into effect. But then it goes straight back to the general rule. And the court stated that any possession order must still be stayed if the appeal is dismissed, and any extension of time to make a second appeal, or extension of time to apply for permission to bring a second appeal was given until after the blanket stay provision has ceased to apply. So again, despite the fact that there is a theoretical right to make an application to lift the stay, the courts are really going against that. And even in this situation, even in respect of appeals, if that appeal is dismissed, it goes straight back to that general rule. So as I touched upon earlier, whilst the blanket stay provision is in essence applicable across the board, there are certain key exceptions. The first is Rule 55.6 CPR possession claims. Now, as set out on screen, a trespass of possession is defined at Rule 55.1b of the CPR as a claim for the recovery of land which C alleges is occupied by persons who entered or remained on the land without the consent or a license of a person that's entitled to possession of that land, but does not include a claim against a tenant or subtenant, whether his tenancy has been terminated or not. However, the stated exception only applies to Rule 55.6 trespass of possessions. And you may be aware that this limits, this provision specifically limits it to persons unknown, so claims against persons unknown. Therefore, it seems the exception does not apply to trespasses where the defendant is known to the claimant. It seems the focus here is upon itinerants on land, and a practitioner could easily get caught here making an application or making a claim, for trespass against a defendant of which it knows. Indeed, some other types of trespass possessions fall outside the remit of this exception, and the blanket stay would seemingly apply. For example, licensees who have become trespassers as a result of a notice to quit are also protected by the stay. So in the usual course of events, the stay would apply unless, of course, you made an application to lift it. But the question that needs to be asked is whether the stay could be lifted if the matter was one that ought to be started in the High Court, as an exceptional or urgent claim against trespassers. This is set out within the practice direction to Part 55, paragraph 1.33, where it states that circumstances which may make it appropriate to start a claim in the High Court are where the claim is against trespassers and there is a substantial risk of public disturbance or of serious harm to persons or property which properly require immediate determination. One could argue, is this an exceptional reason that could fall within the Arkin guideline? Is that something which could be argued as a reason to lift the stay? And could those similar reasons be used in respect of antisocial behavior cases? Well, as I said earlier, it's very risky to take that approach, particularly when the court has stated that the power to lift the stay is a theoretical one, and one which it would be in the most extraordinary circumstances, particularly for the endangering of public health, where it could be utilized. So it may be appropriate in both of these circumstances to make an application for injunctive relief instead, which I'll come on to in a moment. Whilst I do not intend to go into the procedural requirements for trespass possessions, I've set that out on screen. It's set out at Part 55, Section 1 of the CPR and Practice Direction 55A. Finally, just touching upon some case law that may assist you if you do make an application, a claim for possession under the trespass provision, is firstly the case of felon persons unknown, which essentially says that the general rule is that the court must make an order for possession forthwith against trespassers. And the case of Floyd, which makes very clear that that power to make an order for possession forthwith applies not only in the High Court, but to the County Court as well. And Boylan and Son Limited and Rand, which says that the limited exception to postpone possession orders under the exceptional hardship requirements under Section 89 of the Housing Act 1980 doesn't apply to trespassers. And Malik and Fassenfeld, which didn't really go into much in respect of forfeit possession orders, but tried to suggest that McPhail was bad law. But this was only said in passing, and it was not what the majority of the judges ruled upon. In essence, they stayed away from that particular question. And to this day, McPhail does remain good law. However, that case is quite important to the extent that it deals with some public cases dealing with publicly owned land and the application of Article 8 to trespass possession proceedings. So it may be worth just looking into that case, especially if you're making a claim for possession in respect of publicly owned land. The second stated exception is in relation to interim possession orders, which are essentially an accelerated method to remove trespassers from the claimant's premises when they are occupying those premises without their consent. And once an IPO has been served, the trespasser must vacate within 24 hours or they'll be guilty of a criminal offence. And then there'll be a return date for a final hearing of the possession claim. The procedural requirements again set out on screen, Part 55, Section 3 and PD51Z of the CPR. The third and final stated exception is in relation to applications for agreed case management directions. Here, one must go back to Arkin and Marshall. And in that case, it was decided that if parties agree directions, they can apply to the court to have the directions embodied in an order, but nothing more. They cannot apply to enforce the agreed directions during the currency of the stay. Just going back to the judgment itself, the court did state that if either party fails to do what it agreed to do during the period of the stay, the other party will, no doubt, be able to rely on that circumstance once the stay is lifted. It will be able to ask the court at that stage to take the conduct of the other party into account in making revised directions. So there is, despite the fact that you can't go to the court to enforce your directions, the safety net is there that if they are not complied with during the currency of the stay, when you do go back to court, that will be taken into account when the court makes its revised directions, and the sanction could be applied as a result of failing to comply with those directions. And the reason why, and the court went into this, the reason why the court didn't want to allow applications to be made to enforce agreed directions or simply because there is merit in simply allowing directions to continue during the currency of the stay. In essence, by the time the stay has ended, there will be an established timetable for directions, so there won't be a rush to make applications for directions. It allows parties to obviously get on with directions during the currency of the stay. For example, if disclosure can be complied with, then obviously that's something that can be done during the currency of the stay. And once the stay has ended, the timetable can be adjusted. So given the blanket stay provision and the high threshold to meet in order to satisfy a court to lift the stay, it may be more worthwhile for the practitioner to consider applying for injunctions as an alternative or in addition to issuing claims for possession whilst the stay is in force. This may provide a less risky approach to swiftly determine matters which are factually the more serious types of cases, as set out on screen, for example, serious antisocial behavior cases, breaches of tenancy, or certain conduct which breaches lockdown rules or impacts on those self-isolating, for example. No doubt, the express exclusion of injunctive relief from the outset of the introduction of the blanket stay provision makes it clear that it is intended to make use of this form of relief during the currency of the stay. A key example I've put out on screen is University College London Hospital and MB. This case involved the NHS Trust, who made a claim for possession in addition to a claim for an injunction in relation to a bedroom in its hospital. A patient was residing in that bedroom. It had a license to occupy that bedroom, but was no longer in need of inpatient care. So that claim for possession and injunction was made. Of course, the possession aspect was stayed in line with PD51Z, but the court did agree that an injunction could be granted because the court stated that a property owner is in general entitled to an injunction to enforce its rights as against a trespasser. In this case, the license is terminated and the patient was therefore a trespasser in respect of the hospital. So what can the practitioner do right now whilst the stay is in force? Well, they can start issuing notices seeking possession. You may be aware of Section 81 and Schedule 29 of the Coronavirus Act 2020, which extended the notice requirements to 3 months in respect of certain residential tenancies in England and Wales. Those provisions are in force until 30th of September at present. However, the general guidance from the government, as set out on screen in the third point, is that notices seeking possession should not be served unless there was a very good reason to do so. This only seems to be guidance, but nonetheless, it's unhelpful because there's no real definition of what very good reason means within that particular document or elsewhere. My thoughts are that, well, rent arrears cases may not fall within that threshold, but antisocial behavior cases, for example, may do so. It's important to give notices in that respect because it allows the tenant to become aware of what the landlord's intentions are. So it may force their hand, it may affect their behavior as such, especially in respect of ASB cases. So it may be worthwhile at this stage to get the ball rolling if you are satisfied that there is very good reason to do so, to start issuing the notices. If your notice has already been served and has expired, or you're dealing with a Section 21 notice in respect of ASTs, where the notices themselves are about to expire, or the validity is about to expire, that may also amount to a very good reason for issuing proceedings during the stay. You'll note that issuing claims for possession simply is that. Once it's issued, the claim is stayed. But once you're in there, you're in there. And what my thought is that landlords could start to prepare and issue proceedings, particularly in respect of ASB cases, so they are effectively in a queue, and therefore near to the beginning of that queue. So when the stay has ended, you're able to go along with your claim for possession as quickly as possible. However, it's important to stress, both in respect of issuing notices and issuing claims for possession, there has to be a very good reason. Fortunately, there isn't much helpful guidance on this. And as I say, it seems the more serious cases will fall within that definition. Rent arrears cases, more likely not. So what will the state of play be once the blanket stay provision ceases to apply? Of course, there will be a backlog of cases, problems in terms of efficiency, and of course, the majority of the hearings at this stage, at least, and most likely once the stay has ended, are likely to be dealt by way of video link or by way of telephone, unless the matter is of certain urgency or complexity that it requires to be dealt with in person. One can also question what the block listing procedure will be like and whether that will work in practice. In terms of more complicated hearings in particular, the question is, will duty solicitors be able to assist defendants in that situation? Will there be enough around to assist those defendants? And even when matters are dealt with by way of video link or telephone, again, will there be a duty solicitor available? These are certain things which have been a hot topic of debate online and in the news. And again, that may impact the access of to justice for a particular defendant, particularly those who can't afford proper legal representation or can't even afford a computer, for example. And those are the sorts of defendants we do see in courts when dealing with possession claims. And therefore, there is a risk that fair representation won't be provided. So thank you all for listening. I hope this webinar has been useful. I will wait a couple more minutes in case you have any questions. There is the Q&A you can use on the screen. I then shall collate those questions and pick the most popular ones and provide a response along with the webinar once it has been uploaded. My email address is also at the bottom of the screen, so you can email me your questions as an alternative, and then I will respond accordingly. Thank you again. I hope you all do have a good day.